Welcome everyone to this event, this webinar organized by the Amsterdam Center of European Law and Governance on the Komstroy decision by the ECJ and the future of the Energy Charter Treaty. My name is Ankersmit and I'm assistant professor at the University of Amsterdam, and I'll be moderating the webinar of today. We have three very distinguished speakers to talk about this significant judgment that was handed down on the 2nd of September of this year, where the Court of Justice, in a nutshell, found that the ISDS arbitration mechanism in the Energy Charter Treaty is incompatible with EU law insofar as it relates to intra-EU disputes. So we have three distinguished speakers. The first is Professor Alessandra Arcuri, who is professor in international law at the Erasmus School of Law, and she holds a chair in including global law and governance, and is currently also a Fernand Braudel Fellow at the European University Institute in Florence. Then we also have Professor Harm Schepel, who is a professor of economic law at the University of Kent and also an alumnus of the University of Amsterdam. And his research interests are mainly in the legal institutionalization of capitalism on different levels of governance. And lastly, we have Professor Eckes, who is professor of European law at the University of Amsterdam and director of the Amsterdam Center for European Law and Governance. Just a few words on how we're going to proceed with the webinar. In first, the three speakers will give an introduction to their topic of 10 to 15 minutes. This will be recorded. And then afterwards, after these three interventions, we will have time for questions to the speakers on today's topic. So without further ado, I would give the word first to Professor Harm Schepel.
I even managed to unmute myself. That's progress. Thank you, Laurens, and thank you all for being here. So 20 years ago or so, we had a debate in EU law about constitutional pluralism, and that debate, it has since degenerated a bit, but was about the intrinsic nature of legal systems to declare themselves supreme. And so the thinking was, under the German constitution, there is no way that the German Constitutional Court can accept the supremacy of EU law. And as a matter of EU law, there is no way that the Court of Justice can accept that rebellion by the German Constitutional Court. Now, I'm not saying this is the same thing, the relationship between EU law and international investment law, but I am saying that it is a problem that is not going to be solved by EU law. And so what Komstroy does, finally, is make it very clear that investment arbitration as between member states is incompatible with EU law. Now, a number of points to be made about the EU law perspective, and then I'll try and draw it out a bit to the perspective of arbitration tribunals acting under the ECJ. International investment law is fundamentally incompatible with EU law for several reasons, but mostly because it compels member states to do things that are not allowed under EU law, basically to discriminate against companies that it may not discriminate against under EU law. This is true for both intra-EU bids for the ECT, but also for European agreements. Now, my pet theory about the way all of this has evolved is that it starts with a devil's pact within the European Commission 15, 20 years ago, whereby a deal was made, that is, the legal service was allowed to go on arguing that intra-EU bids and the ECT were incompatible, but DG Trade could go on and sign international trade agreements, knowing full well that their compatibility with EU law was questionable. And that starts a bit of a tortured road in the stance of the EU vis-a-vis investment law. Now, the European Commission, and this is a fairly long-standing practice, and not just since Achmea, has argued in front of ECT tribunals for a very long time for several reasons that inter-EU arbitration under the ECT was not to happen. And they come up with several arguments that the Lisbon Treaty should be seen as a subsequent agreement under the Vienna Treaty on the Law of Treaties, basically supremacy clauses and all sorts, and the Commission has always been rebuffed. There are a few decisions, Electrabel mostly, whereby a tribunal argues that in case of conflict, perhaps EU law could proceed over the investment treaty. But that is just the thing, in case of conflict. And tribunals go out of their way to argue that there is no conflict whatsoever between the substantive issues under the ECT and EU law. And so this, I'm afraid, will continue. Komstroy does not change from the point of view of international law the basis of consent and the autonomous nature of international law obligations as they see it under the ECT. It will, however, make things vastly more complex and expensive. For one thing, because of complicated enforcement measures that need to be taken, whereby we all need to find each other's assets outside of the EU, whereby tribunals or parties rather will try very hard not to have the seat of arbitration somewhere within the EU, because that might make things more complex, and so on and so forth. But in principle, all that Komstroy does is make clear that member states have duties under EU law that are not compatible with their duties under the ECT. One thing that Komstroy might do, but then we'll have to wait until Friday when the Dutch High Court, the Hoge Raad, decides on the UCOS affair. And it might be that the Hoge Raad will have to send a preliminary reference to the Court of Justice. And that'll be great fun, because then the Court of Justice can decide on Khodorkovsky and Putin and $15 billion. And I don't actually think the Court of Justice really wants to do that. So we'll have to see how that goes. So I think it's important to realize that Komstroy does not signal the end of the ECT. It does not signal international law, the end of international law obligations of member states. Those things will have to happen politically. They will have to withdraw and terminate and do what they can to help the transition. But I don't think there will be a single investment tribunal who will decide a case after Komstroy in a way different than they would have before Komstroy. And that is basically all I have to say, Laurens.
Thank you, Harm. That's certainly thought-provoking, I think, because we have seen quite strong reactions from the investment arbitration community. Indeed, saying what you're saying, it's business as usual, but maybe perhaps a bit more complex, indeed, in terms of the enforcement, and that does put the ball in the court of the member states and also the EU, I think, to make sure that they will respect their obligations under EU law. But maybe Professor Christina Eckes can say a few words about that in her intervention. But first, I would like to give the floor to Professor Alessandra Arcuri.
Thank you very much. Thanks for the previous intervention. In fact, I linked to that, but actually in a non-legal way, because I will focus on the reaction of the international arbitration community. And as Lawrence, you were already saying, Komstroy has triggered a number of harsh critiques. And in this short presentation, I will argue that these reactions are problematic in terms of morality. And I defend this thesis in 3 steps. The first is to clarify what I mean by morality. The second is to put Komstroy in context, that is, in a time in which we need the green transition. And building on these 2 steps, I reflect on the morality of the reactions of the arbitration law industry and conclude by raising one question in this respect. So let me start by clarifying the idea of morality I'm subscribing to. Rather than taking a broad legal theory perspective, I start from somewhere and focus on what I label immorality in context. And so my argument is, if we find some moral values that is shared by the contemporary international community and can point at instances that violate such values, we can derive from their yardsticks for finding immorality. So in terms of shared value, I think we can all agree that there is widespread consensus that some of the biggest challenges today are halting climate change. So that halting climate change is a good thing. And so is diminishing socio-economic inequalities. So from this, it follows that facilitating any business implicated in causing climate change and any system reproducing socio-economic inequalities is immoral. So very simply, I take this as my 2 yardsticks for immorality. This was the first step. So second step, Komstroy can be read as part of a line of jurisprudence of the Court of Justice of the EU, which articulates the incompatibility of intra-EU investor-state arbitration with EU law. And we know what are the reasons, and I think probably Christina will elaborate on that, but principle of sincere cooperation and so on and so forth. Komstroy is important though, because it clarifies that intra-EU investor-state arbitration based on the Energy Charter Treaty is also incompatible with EU law. So the European Court in Komstroy concludes that Article 26(2)(c) of the ECT, the Energy Charter Treaty, must be interpreted as not being applicable to disputes between member states. This judgment could then be seen as, although here I'm disagreeing with her, as a death sentence for intra-EU investor-state disputes under the ECT. Rather than commenting on the details of the reasoning of the court, I want to draw the attention on what the ECT stands for today. The scholars have amply shown how the ECT plays a particularly significant role in protecting foreign-owned coal power plant assets. And here I'm quoting from a study of 2020 by Kilatiana Hara and Lorenzo Cotula, which lucidly illustrates how the ECT protects basically the fossil fuel economy. Now, the pending cases in the Netherlands, which we all know, Uniper and RWE, are exemplary in this regard, but also other cases such as Rockcopper versus Italy show how the ECT can be turned into legal mechanism of last resort to protect the fossil fuel industry. So basically, when everything, all type of lobbying has been done and has miraculously been unsuccessful, often if we look at these cases, is because there has been a strong legal mobilization of people against the fossil fuel industry, then the mechanism of last resort is to mobilize the Energy Charter Treaty. So very shortly, Komstroy, we could see that Komstroy represents an incremental, albeit significant rupture with the past and could inflict a serious blow on the ECT legal regime, which is arguably facilitating the fossil fuel economy. So as mentioned before, practicing international investment lawyers have widely criticized the Komstroy judgment. And combining what I've said so far, so my first one step and step 2 at the macro level, and somewhat oversimplifying, I concede the opposition to Komstroy ruling could be seen as morally problematic as it offers ammunition to the fossil fuel industry to resist climate policy. But let us look at some of the specific reactions to come to a more nuanced assessment. And I focus on two specific reactions, which in my view are most illustrative of the morally problematic response by the international arbitration lawyers. Firstly, several law firms have encouraged investors to evade the effects of the European Court ruling. For example, Allen and Overy in their website with a comment advised, and I quote, EU investors to restructuring their investment from outside the EU. And this incitement and unsolicited advice on how to elude the European Court ruling is done publicly. Clearly, this is an encouragement to de facto contravene a ruling of the most authoritative court in the EU. Now, to be fair, this is nothing new under the sun. The advice of restructuring or structuring investments outside the EU has been widely offered since ACMEA. And while it might be perfectly legitimate to criticize the court ruling, a straight advice on how to elude the effects of the judgment by this court should let us pause and reflect on the moral compass of the actors who arguably should be respectful of the law. So let me be clear, there are certainly instances where it would be moral to encourage a client to disattend the law. Think for once the history and the case of the conscientious objector. But I think it would be quite grotesque to think that an advice to rich multinationals to restructure, and incidentally restructuring is one of the legal techniques most used to elude taxation, is not comparable to the case of the conscientious objector. So on its face, this advice, in my view, is immoral because it facilitates rich corporate actors to dodge the law. In so doing, the lawyers contribute to further augment the power of already very powerful actors. Probably to legitimize this advice in reaction to Komstroy law firms, have also felt the need to construct a narrative according to which the ECT is instrumental for decarbonization. And for example, in the reaction to Komstroy, lawyers at Gibson Dunn write, and I quote, the Court of Justice of the European Union's decision may undermine investor confidence at a time when the EU is seeking substantial private investment in its energy sector as part of its efforts to decarbonize. Yet this narrative is really far from credible. The very structure of the ECT, with its clauses aiming at a stable environment, points at the very different story. And it is not only the text of the agreement, but also how it has been interpreted in the past that suggests that the ECT can be successfully used by the oil industry to increase and possibly slow down the green transition. Many of the carbon majors, including Chevron, Exxon, and Total, have already used ISDS disputes and won. And the study of Tinehara and Kotula, which I mentioned before, tells us that the cumulative value of stranded assets in the power sector in G20 countries between 2016 and 50 could be up to some 1.6 trillion US. And the ECT protects at least 51 power plants exposed to stranded asset risk. So in order to decarbonize, we clearly need to change. We need to destabilize the fossil fuel economy. We need a legal environment that is more sensitive to Paris and to ecological crisis. We don't need the ECT. And in this context, it is worth mentioning that the Law Students for Climate Accountability Initiative, a very nice initiative I invite you all to look at, which is based in the US. So this group of students, observing that law firms constitute an indispensable pillar of support for the fossil fuel industry, have started to assess law firms' involvement in the fossil fuel economy, and in a 2021 report found that the top firms facilitated a stunning 1.36 trillion US dollars in fossil fuel transactions. In this report, they have assessed law firms with scorecards to see how they fare in facilitating the fossil fuel industry. And incidentally, Allen and Dovery and Gibson Dunn, whose negative reaction to Komstroy I quoted previously, both received an F score, which is the worst you can get, meaning they have been on the front seat to support the fossil fuel industry. So I realized that my intervention is limited, and it is really just catching the beginning of a conversation that I think we as lawyers should have. And even if sketchy, I think we should at least consider the possible implications of an analysis questioning the role of these firms in molding a legal landscape favoring the fossil fuel industry. So assume for a second, of course, what I said can be questioned, but assume for a moment that I would be correct in claiming that some law firms reacted to Komstroy in an immoral way. That is, in a way which could potentially facilitate the fossil fuel industry and enhance form of environmental racism, which are intimately bound up with the fossil fuel economy. If I would be correct, my concluding question then is, should public institutions from the EU and the European member states stop asking the services from these firms? And this was my concluding question. Thank you.
Thank you, Alessandra. That is certainly thought-provoking, and potentially also gives a bit of a different perspective than that of Harm, who was a little bit more pessimistic on what could be done from the side of, let's say, the social side from the investment arbitration community. Okay, I think we can now move on to the intervention by Professor Christina Eckes.
Thank you, Laurens, for organizing this event. And I will take us back a bit to Komstroy, because I feel I enjoyed the past two presentations, mainly because they were very contextual around Komstroy. So I want to make a few points on Komstroy to start with. So in total, I want to make 3 points. First, some legal issues from Komstroy, which might be repetition, but which I think nonetheless are important to explicate. The second is specifically on jurisdiction and how that is discussed by arbitration tribunals. And the third is on autonomy and loyalty, and the obligation of the member states, national courts, and potentially international companies. And I have thought in that respect, Alessandra, this was very inspiring. It actually added a thought to what I'm going to say later. So first of all, Komstroy. The court didn't have to answer the question. I think anyone who has read the judgment knows the court addressed a question that it could have easily avoided by speaking about the question of whether this particular case concerned investment. And since it rejected that, it could have stopped there. So it clearly chose to address a hypothetical question, namely the question of compatibility of intra-EU investment with EU law. And that is, of course, something that you can procedurally criticize the court for. However, I think you need to take into account in a contextual reading that this is a pressing question. It is a real life question that is out there, and that is despite the fact that I would say that Komstroy did not bring any surprises, that Komstroy justifiably, the Court of Justice relied on Achmea and said, we have already said this. And I think they have. So while on the one hand, I think Komstroy did only specify something that is already case law, it nonetheless filled a gap in need of, if you like, legal knowledge. And that in light of the cases mentioned, for example, by Alessandra on RWE, Uniper in the Netherlands, but many others, billions of claims of billions of euros in intra-EU arbitration in the context mainly of the fossil fuel industry, but of course also millions of claims of renewable energy. So first of all, this is also a point I would like to make, namely the significantly larger claims made by the fossil fuel industry and the significantly lower claims made by the renewable energy companies, if you compare that on the website of the Energy Charter Treaty. And that all, of course, in light of the recent UN report that member states fail to meet their obligations under the Paris Agreement, and in light of the fact that the Energy Charter Treaty, however we want to interpret it, and whether we want to say, okay, it protects investment more broadly, logically protects the status quo. And in light of what Alessandra said, namely that climate change is, I think, largely agreed, the greatest problem, challenge, threat of the 21st century, the question is, should we at all be part of a treaty that protects a status quo that we need to move away from, namely the status quo of fossil fuel dependency of all the states, those that produce fossil fuels and those that use them. So in that light, I think there's a lot to say contextually to justify why the court addressed the hypothetical question. The next point is, as I said, no surprises. I mean, it repeated that the arbitration tribunals are not courts or tribunals in the sense of 267 of the TFEU, so they cannot ask preliminary questions. They're not considered part of the European courts. And that just makes sense. They're not bound by primacy. They're not independent. They are not embedded in the constitutional context of the member states. So no surprises. And also, I think one can hardly disagree. But then it, of course, the court offers several paragraphs on general consideration on the autonomy of EU law. And I think this is also essential. And that leads me to my third point of my intervention. Namely, it stresses again that the autonomy protects the essential characteristics of EU law. And it refers primarily to the preliminary ruling procedure and Article 344, so that member states have to bring their disputes in the context of EU law to the Court of Justice and cannot rely on external jurisdiction. And this is just the procedural mechanisms that protect these essential characteristics of EU law. And I would like to argue, and I have argued in the past, essential is really what we should see them as. Namely, if they fall away, EU law is not EU law as we know it. So they are essential in the sense that they characterize the nature of EU law, and without them, we do not have the EU in the way we have it. And the substantive characteristics that one would need to mention here are, of course, primacy and direct effect. So I would like to say that the Energy Charter really becomes the context in which the worst fears of the Court of Justice in the context of autonomy play up in practice. So we have seen autonomy in many contexts, rejection of accession to the ECHR. We have seen it in Opinion 117 with regard to CETA. It has been mentioned in different ways in CADI, one of the landmark cases of the past. But here we will actually see a clash that we haven't seen before, because I do agree with Harm, the tribunals will not rule in any way differently after Achmea/Komstroy. So companies will be restructured, as Ellen and Overy suggests, as Alessandra has pointed out. Courts in other jurisdictions will simply enforce these awards. Money of the member states in other jurisdictions will be gone after, and the jurisdiction of the Court of Justice will effectually be circumvented. And the question is, of course, not just on these substantive issues, not just on these claims, but also on EU law issues. So there will be an actual threat to the autonomy, and yeah, we will see what comes from that and how to deal with that. And that will be my third point. And one point I still want to mention with regard to Komstroy, and that is, of course, there's one big uncertainty that we haven't discussed here. And that is that the Court of Justice said the Energy Charter Treaty may require member states to comply with the arbitral mechanisms for which it provides in the relations with investors from third states. So it may also apply to extra EU arbitration. The Court of Justice consciously leaves that open, but by using, of course, the legal term may, it leaves it literally open. It does not exclude it either. But that takes me to my second point, and that's, of course, the whole point of jurisdiction. And do these arbitral tribunals have jurisdiction? And yes, they will accept jurisdiction, as Harm says, but we also have in the past already rulings that make that very clear with regard to Achmea. So nothing will change, because Komstroy is nothing new under the sun. And we have, for example, the Solis Badajoz case against Spain, where no less than the president of the ICJ, namely Joan Donoghue, said exactly that. It discussed, she wrote the report at the time, she wasn't the president yet, but I mean, this is not any odd arbitrator. This is someone who has a core function in the development of general international law. And she completely in that, or as part of the tribunal, obviously, I mean, not she personally, rejects the argument on jurisdiction. So rejects the respondents, Spain's claim that the company, the claimant, is not an investor under the ECT because the ECT does not apply to disputes between nationals of the member state and another EU member state. So there's a lot of discussion in that particular award, which I find interesting, and that is it discusses EU law as international law, as domestic law, and potentially as fact. So in which ways EU law plays a role here. And it is interesting in that respect that the Energy Charter Treaty puts forward that international law that actually protects another treaty, so international law treaty, that protects investment stronger, so puts substantive protections forward that are more favorable to investors than the Energy Charter Treaty, can actually lead to a situation that the Energy Charter Treaty is not applicable. And if you thought that EU law was international law, you could of course question whether maybe free movement of capital, whether there's anything to find that you could make an argument on that basis. But you can't, because the point is, of course, that is specifically the criticism of ISDS and of the Energy Charter Treaty, namely that it treats investors too favorably, more favorably than other persons. Then that is the inequality argument that Harm put forward at the beginning. So you can't avoid it by arguing that EU law is international law. And then of course you could argue that EU law is domestic law, but then you fall into the trap of Article 27 of the Vienna Convention on the Law of Treaties, which says states cannot rely on domestic law as an excuse for failing to comply with treaty obligations, hence the Energy Charter Treaty. So even if it was seen as autonomous, distinct legal order from public international law, or what the Court of Justice puts forward, if tribunals accepted that, they could still not allow European law to take primacy over the European Energy Charter Treaty. So the conclusion also in that award is the Energy Charter Treaty is the applicable law, and EU law is not part of the applicable law to that case. And that is exactly what will be argued again. And I mean, the parties made many other arguments that there's a specific reference to regional economic integration organizations, that they can have more preferential treatment amongst themselves. All this was put aside. We can discuss these other legal discussions maybe later in the question and answers. So in short, there's no way out, either as international or domestic law. It won't. It will stay. The tribunals, most likely in the majority in any event, will rule exactly as they have. However, do EU member states, national courts, and potentially also private persons, so mainly legal persons, maybe lawyers, law firms, as Alessandra referred to Ellen Overy earlier, have an obligation to withdraw from the Energy Charter Treaty, to not cooperate, to not incite companies to restructure and circumvent EU law in order to be able to bring cases under the Energy Charter Treaty, depending on which actor they're talking about. First of all, I would like to mention that political pressures are growing. I mean, there are an increasing number of member states that actually calls for a public discussion of withdrawal. France in 2021, but also already in, 2020, when the member states made the agreement to withdraw from all bilateral investment treaties intra-EU, and they excluded the Energy Charter. So they said, well, we regulate this here and we will consider the Energy Charter at a later stage. So they left it again open, so which is a clear sign of disagreement. And I've been trying to get after which member states were in favor and which were against, but one can of course speculate. One can speculate on the basis of the traditional positions of member states vis-a-vis arbitration. So I think probably, and this is pure speculation, the Netherlands should have considered that more in depth before in 2020 than they could now in the light of RWE and Uniper. So I think what we can take from it safely is the fact that there is that there was already then a number of member states in favor of dealing with the Energy Charter in some way or other. So then we have, of course, the slow progress of if you can speak of progress, I mean the slow process of modernization of the Energy Charter Treaty, which looks like it's going nowhere, admittedly, since 2017, and a lot of pre-discussion and then several rounds of negotiations in 2020 and potentially also 2021. So the mandate that the Commission had to reinstigate the right to regulate into the Energy Charter Treaty is likely, it's not going to work. It likely fails on the fact that we have 54 signatories and that there are many countries that have significant interests in not changing this and not strengthening the right to regulate. So in this light, so the permanent clash, the fact that investment arbitration tribunals will not decide differently, and we have a clear position of the Court of Justice that that is against EU law, at least in the context of intra-EU arbitration. What are member states? What should they do? I have mentioned the importance of autonomy as a core feature and really as something that we should see as defining the EU, as being central to the functioning of an EU, which is a lot under pressure from other corners. We could mention the rule of law crisis, and we can maybe in the question and answers discuss whether the rule of law crisis actually undermines our argument, because it means that in certain member states, claimants cannot necessarily rely on an independent judiciary. I think that's an important question also to address in the question and answers. But okay, we have this autonomy of EU law, which is highly important. And then we of course have sincere cooperation or loyalty. And I mean, I've argued in other places that loyalty in the external context is applied more stringently by the court, and that it has to be applied more stringently because neither other states nor international arbitration tribunals or other courts in other states or any other international court is bound by the primacy of EU law. So in order to protect the unity of the European Union in international representation, we do need to rein in member states more strongly. And I think there are many cases I could mention in that context, amongst others, the bilateral investment treaty cases of the 90s that we could discuss, or PFOS, the case where Sweden was reined in for its actions under the Stockholm Convention. So there are many cases that confirm this more stringent application. So one could argue that from the standpoint of EU law, and that's the standpoint I'm taking, that member states are simply obliged to withdraw from the Energy Charter Treaty in order to avoid the constant clash and in order to avoid the undermining of the autonomy of EU law. And then, of course, that obligation extends, and there's no question, to national courts, so that national courts cannot give effect to any awards that are brought to them, simply because they're equally bound by the loyalty. And then we get to international actors, private actors. And here, what came to my mind when Alessandra was talking is actually the German term of Organe der Rechtspflege. So the position of lawyers as organs of taking care of the judicial order. That is how we call them in German. So they have a specific position. Lawyers are not just any actor under the sun, but they have a mandate, namely to contribute to the working state rule of law, state of law, whatever, Rechtsstaat. And I think in that light, it is even more questionable, of course, for lawyers to act like this, or law firms to suggest that, than for big multinationals to actually do it. Thank you. That's my point on Komstroy, and I'm looking very much forward to discuss that in the question and answers.
Thank you, Christina. Very, very interesting intervention. And I think, well, I myself have many questions, but I will not abuse my position as chairing this meeting, and I will first open the floor